The danger is not only the government letter. The danger is the 65-day clock connected to that letter. If you are retired, receiving Social Security, or still carrying an old federal student loan or Parent Plus loan, a defaulted loan can eventually put part of certain federal payments at risk through the Treasury Offset Program. But let me draw the first safety boundary immediately. One late payment does not mean Social Security is taken tomorrow, and as of July 23, 2026, the most recent official Department of Education announcement says involuntary student loan collections through Treasury Offset and administrative wage garnishment remain delayed. That delay matters. It gives borrowers additional time. But it does not erase the default, cancel the balance, or guarantee that collections will never restart. So this video is about what the government is legally able to do, what the current delay means, and how to use the written notice and its 65-day window if you receive one. Stay with me because near the end I will reduce this entire process to 5 questions you can write down before calling the official loan holder. Before we go further, subscribe and turn on notifications. Student loan rules, repayment options, collection policies, and government deadlines can change, and older borrowers often discover the change only when a letter arrives. I break these notices down in plain English so you can verify what is real before money is affected. First, understand the 3 stages people often mix together: delinquency, default, and collections. Delinquency begins when a scheduled payment is missed. For many federal student loans, the loan generally enters default after at least 270 days without the required payment. Default is a serious account and legal status, but default is not exactly the same as an active Treasury offset. Federal Student Aid explains that when a borrower has gone more than 360 days without making a payment and has not taken action to resolve the default, involuntary collection methods may begin. Those methods can include administrative wage garnishment and Treasury offset. Treasury offset is the federal process that can withhold a tax refund or certain other federal payments and apply the money to a delinquent government debt. Those federal payments can include part of Social Security benefits. Now for the current reality check. On January 16, 2026, the Department of Education announced a temporary delay in implementing involuntary collections on federal student loans, including the Treasury Offset Program and administrative wage garnishment. The department said the delay would give borrowers more time to evaluate repayment and default resolution options while repayment reforms were being implemented. That means this is not a claim that every person in default is having Social Security reduced right now. Collection authority still exists, however, and the department described the delay as temporary. The safest use of this breathing room is to resolve the default before another collection date is announced, not to assume the debt has disappeared. The next distinction is just as important. A private debt collector is not the same as the federal government collecting a federal student loan debt. Many federal benefits have important protections from ordinary private collection activity. A private collector cannot simply call Social Security and order the agency to reduce your retirement benefit. Depending on the debt and the circumstances, a private creditor may need a lawsuit, a judgment, and a lawful garnishment process. Federal benefit protections may still matter after the money reaches a bank account. A defaulted federal student loan is different because the debt is owed within the federal system. The government can use an administrative collection mechanism called the Treasury Offset Program. That is why the statement Social Security is protected is not a complete answer here. The better question is, protected from whom, for what type of debt, and through which process? This does not mean all Social Security can be taken. It does not mean every overdue loan triggers an offset. It does not mean a caller can frighten you into paying immediately. It means that a defaulted federal debt can enter a special federal collection process after notice and an opportunity to respond. And that brings us to the most important object in this entire video, the written notice of intent to offset. Federal Student Aid says that before a student loan treasury offset begins, a written notice is sent to the borrower's last known mailing address. The notice explains that offset is scheduled to begin in 65 days and describes the borrower's options and rights. That letter is not junk mail. It is not merely an account reminder. It is an action notice. The first mistake is throwing it away because the loan is old. The second mistake is assuming the 65 days begin whenever you finally open the envelope. The third mistake is calling a number from an advertisement, text message, search result, social media comment, or paid debt relief company instead of using the official account and the instructions in the notice. When the letter arrives, keep the envelope. Write down the date printed on the notice, the date you received it, the debt amount, the agency or loan holder named in the letter, and every deadline in the instructions. Scan or photograph every page. If you recently moved, update your address through the official federal loan system because the notice may be sent to the last known address on file. Do not guess about which date controls. Federal student aid describes some protections by reference to the date the notice was sent, while the letter may also include submission, receipt, or postmark instructions. The notice in your hands controls the procedure you must follow. Act early rather than treating day 65 as the day to begin. Instead of trying to memorize 9 separate actions, think of the response as 4 moves. Move 1 is to verify the debt, the status, and the clock. Log in directly at studentaid.gov. Type the address yourself or use a saved official bookmark. Do not use a link sent by an unexpected caller or text message. Review the dashboard in the My Aid section. Federal Student Aid says a borrower with a federal loan in default should see a warning message, and the account details can identify the loan type, balance, status, and servicer or holder. You are trying to answer 4 basic questions. Is the loan federal? Is it merely delinquent, officially in default, or already assigned for collection? Who currently holds or services the debt? And has a notice of intent to offset actually been sent? The loan could be a direct loan, an older federal family education loan, a Perkins loan, or a Parent Plus loan. That distinction matters because the available resolution options are not identical. If a defaulted loan is held by the U.S. Department of Education, the official account may direct you to the default resolution group. MyEdDebt.gov is the department's separate debt resolution website for defaulted loans and certain grant debts assigned to that group. It uses a separate account system from Student Aid. Gov, so separate login requirements do not automatically mean the site is fake. The official default resolution group phone number listed by Federal Student Aid is 1-800-621-3155 if Student Aid. Gov names a guarantee agency or another official servicer. Use the contact information shown in your account instead. Do not call and ask only, "Am I okay?" That question is too broad. Ask for specific facts. Is my loan currently in default? Has this debt been certified for the Treasury Offset Program? Was a notice of intent to offset sent, and what date was it sent? What is the exact response deadline shown in your system? Can you send me a written breakdown of the principal, interest, and collection costs? Keep a call log. Write down the date, time, representative's name or identification number, and what you were told. Ask for important answers in writing whenever possible. Move 2 is to compare the 3 main routes for getting out of default. You do not need to memorize every technical rule at once. For now, remember the basic difference. A repayment agreement may address the immediate notice. Rehabilitation is a slower repair process. Consolidation can be a faster reset, but it comes with trade-offs. Start with the route most directly connected to the 65-day letter, a formal repayment agreement. Federal Student Aid's default guidance says that a borrower may avoid Treasury offset by entering a repayment agreement and making the first required payment within the 65-day period measured from the date the notice was sent. The words formal agreement matter. Sending a random payment is not the same as completing the required agreement. Ask what amount is required, when it must be received, how the agreement will be documented, and what happens if a later payment is missed. The exact question is, if I complete this agreement and make the first required payment by the deadline, will my account be removed from the offset process? If the deadline is already passed, do not assume nothing can be done. Federal Student Aid says a borrower may still be able to stop offset by entering repayment, although the required terms may be different. Call the official holder immediately and ask what action is available at that stage. The second route is rehabilitation. Think of this as the slower route that repairs the default status over a series of payments. Rehabilitation requires a signed agreement and, for most direct loan and federal family education loan borrowers, 9 on-time voluntary payments within 10 consecutive months. After successful completion, the loan is removed from default. The department also asks the credit reporting agencies to remove the record of default, although earlier late payment information may remain. The key limitation is timing. Rehabilitation is not instant. Under normal collection rules, signing the agreement does not by itself guarantee that an offset notice disappears that day. Ask one practical question: at what point in rehabilitation would my loan be removed from Treasury Offset, and what must happen before then? The January 2026 Department announcement also said new law gives eligible borrowers an additional opportunity to rehabilitate a defaulted federal loan. That may matter to someone who used rehabilitation in the past, but the official loan holder should confirm eligibility and the steps required. The third route is direct consolidation. This can move some eligible loans out of default more quickly than rehabilitation, but faster does not automatically mean better. Consolidation creates a new loan. Unpaid interest and collection costs may be added to the new balance. The earlier default history may remain on the credit report. The repayment plans available afterward depend on the loan type, the consolidation date, and current federal rules. Now place Parent Plus loans in a separate mental box, because this is where generic advice becomes dangerous. A Parent Plus loan is the legal responsibility of the parent borrower, not automatically the child whose education was financed. If the loan defaults, the collection risk belongs to the parent whose name is on the loan. Parent Plus loans also have special repayment plan restrictions, and plan eligibility changed in 2026. Do not accept a promise that consolidation will automatically place every Parent Plus borrower into the lowest income-based payment. Ask the official servicer to state, in writing if possible, which plan would be available after consolidation, what the estimated payment would be, and which protections or prior payment credits could be lost. Here is the short memory aid. A repayment agreement focuses on the immediate collection notice. Rehabilitation takes longer, but can clean up the default status more fully. Consolidation may work faster, but it can change the balance, the credit consequences, and the repayment plans available afterward. There is no universal winner. The best route depends on the loan type, prior history, income, deadline, credit report concerns, and what you can realistically maintain after leaving default. Move 3 is for cases where the debt balance, default, or legal obligation may be wrong, or where an official discharge category may apply. Begin with the hearing right. A hearing is not simply a request for a smaller payment. It is an official way to challenge matters such as whether the debt belongs to you, whether the amount is correct, whether the debt is legally enforceable, or whether the account was properly placed in default. Federal student aid says a hearing request submitted on time within the 65-day Treasury notice period can temporarily pause collection until after the hearing. Follow the exact submission and postmark instructions in the notice. A general phone complaint is not necessarily the same as a formal hearing request. Supporting records might include payment histories, bankruptcy-related records, proof that the loan belongs to someone else, evidence that the balance is wrong, or records showing the loan should not be in default. You can also request documents related to the debt. If the balance looks unfamiliar, ask for the promissory note, payment history, collection cost calculation, and records supporting the default status. Once that issue is clear, there is a second and different question. A hearing asks whether collection should proceed on the debt as it is being presented. A discharge asks whether federal law provides a recognized reason to cancel some or all of the loan obligation. Federal student loans may qualify for discharge in specific situations, including total and permanent disability, death, certain school closures or misconduct, false certification, unpaid refunds, or other categories recognized by federal rules. A discharge is not automatic simply because a borrower is older, retired, unemployed, or receiving Social Security. Ask which official application matches the facts, what evidence is required, where it must be submitted, and whether collection activity is suspended while the request is reviewed. Move 4 is to protect your federal payments and your personal information. If a tax refund or another federal payment has already been reduced, the Treasury Offset Program automated line is 1-800-304-3107. Treasury can identify whether an offset occurred, the date and amount, and the creditor agency connected to the debt. Treasury generally does not decide whether the student loan balance is correct. The creditor agency or official loan holder maintains the debt records and decides questions about repayment, disputes, refunds, and removal from the offset program. So the sequence is straightforward. Use Treasury to identify the offset and the creditor when necessary. Then contact the official student loan holder to challenge or resolve the debt. Do not assume every reduced federal payment is connected to a student loan. Treasury offset can also involve other federal or state debts. Identify the agency before deciding what happened. And be especially careful with companies that use the phrase 65-day deadline to frighten you. A caller may know enough student loan language to sound official. The person may mention Treasury, Social Security, forgiveness, consolidation, rehabilitation, discharge, or a special enrollment window. Then comes the real warning sign: an enrollment fee, a demand for your student aid. Gov password, remote access to your computer, or payment through a wire transfer, gift card, cryptocurrency, or payment app. Stop. The Default Resolution Group and official federal loan servicers do not charge an enrollment, subscription, or maintenance fee to explain federal default resolution options. A legitimate payment should be connected to an official repayment or rehabilitation agreement, not a rescue package sold by a stranger. Never give anyone your federal student aid identification credentials. Never post a Treasury notice, Social Security number, loan account number, date of birth, address, or bank information in a comment section. Now let me reduce the entire process to the 5 questions I promised at the beginning. Question 1. Is this loan federal, and is it officially in default? Question 2. Has my debt been certified for Treasury offset, and what is the exact notice date? Question 3. Which completed action will stop or prevent offset in my case? A repayment agreement, rehabilitation, consolidation, a timely hearing, or an approved discharge? Question 4. What must I submit or pay? By what date, and how will I prove that it was received? Question 5. Can you send the answer and the account breakdown to me in writing? Here is the full picture. A missed payment is delinquency. A long period of missed payments can lead to default. Remaining in default can eventually lead to involuntary collections, including Treasury offset of tax refunds and certain federal benefits. A private collector's threat is not the same as a federal Treasury offset. The federal process includes written notice and an opportunity to respond. Federal student aid describes a 65-day notice period in which certain actions may prevent or pause offset. The correct action depends on whether the borrower agrees with the debt, disputes it, qualifies for discharge, or needs a route out of default. As of July 23, 2026, the Department of Education's most recent official announcement says involuntary federal student loan collections through Treasury offset and administrative wage garnishment are delayed. That is useful breathing room, but it is not cancellation. Use that time to log in at Student Aid. Gov, update your mailing address, identify the official loan holder, request the records, and compare the real options before collection activity resumes. If you are helping a parent, spouse, neighbor, or older relative, sit down with them and review the actual account and letter. Do not rely on memory, and do not rely on a caller's description of the debt. If you feel comfortable commenting, say only whether the loan is the borrower's own federal loan or a Parent Plus loan. Do not post private account information. That distinction can change the available resolution path. Subscribe and share this with someone who still carries an old federal student loan. A 65-day notice is not a reason to panic. It is a reason to verify the debt, protect the deadline, document every step, and act through the official federal system.